ਅੱਜ ਸਾਡੇ ਨਾਲ ਸਟੂਡੀਓ ਦੇ ਵਿੱਚ ਮੌਜੂਦ ਨੇ ਸਿਮਪਸਨ ਥਾਮਸ ਐਂਡ ਐਸੋਸੀਏਟਸ ਤੋਂ ਮਿਸਟਰ ਸਟੀਫਨ ਫਰਗੂਸਨ, ਪਾਰਟਨਰ ਨੇ ਟਰਮ ਦੇ ਵਿੱਚ ਨਾਲ। ਤੇ ਅੱਜ ਉਹ ਜਿਹੜੀ ਅੱਜ ਸਾਡੇ ਨਾਲ ਗੱਲਬਾਤ ਕਰਨ ਪਹੁੰਚੇ ਨੇ, ਇੱਕ ਬਹੁਤ ਹੀ ਆਮ ਜਿਹਾ ਮੁੱਦਾ ਹੈ ਪਰ ਉਹਦੇ ਬਾਬਤ ਜਾਣਕਾਰੀਆਂ ਬਹੁਤ ਘੱਟ ਨੇ। ਅਸੀਂ ਕਿਤੇ ਵੀ ਕਿਸੇ ਇੰਪਲੋਇਰ ਦੇ ਕੋਲੋਂ ਜਦੋਂ ਕੈਨੇਡਾ ਦੇ ਵਿੱਚ ਕੰਮ ਕਰਦੇ ਹਾਂ ਤੇ ਸਾਡੇ ਕੁਝ ਬੇਸਿਕ ਹੱਕ ਹੁੰਦੇ ਨੇ ਜਿਨ੍ਹਾਂ ਤੋਂ ਆਮ ਕਾਮੇ ਵਾਕਿਫ ਨਹੀਂ ਹੁੰਦੇ। ਹੁਣ ਉਹਨਾਂ ਦੇ ਵਿੱਚ ਬੜੀਆਂ ਨਿੱਕੀਆਂ ਨਿੱਕੀਆਂ ਚੀਜ਼ਾਂ ਆ ਜਾਂਦੀਆਂ ਨੇ। ਕੰਮ ਤੇ ਲੱਗਣ ਵੇਲੇ ਸਾਡਾ ਜਿਹੜਾ ਕੰਟਰੈਕਟ ਹੁੰਦਾ ਹੈ ਉਹਨੂੰ ਧਿਆਨ ਨਾਲ ਕਿਵੇਂ ਪੜ੍ਹਨਾ, ਉਹਦੇ ਵਿੱਚ ਸਹੀ ਕੀ ਹੋਣਾ ਚਾਹੀਦਾ ਹੈ, ਗਲਤ ਕੀ ਹੁੰਦਾ ਹੈ, ਕਿਹੜੇ ਗਲਤ ਤਰੀਕੇ ਨਾਲ ਤੁਹਾਨੂੰ ਕੰਮ ਤੋਂ ਜਦੋਂ ਕੱਢਿਆ ਜਾਏ ਤੇ ਤੁਹਾਨੂੰ ਲਾਇਰ ਦੇ ਹੈਲਪ ਦੀ ਲੋੜ ਪੈ ਸਕਦੀ ਆ, ਉਹ ਤੁਸੀਂ ਚੀਜ਼ਾਂ ਪਛਾਣਨੀਆਂ ਕਿਵੇਂ ਨੇ। ਤੇ ਨਾਲ ਦੇ ਨਾਲ ਜੇਕਰ ਤੁਹਾਡੇ ਨਾਲ ਕੰਮ ਦੇ ਉੱਤੇ ਕਿਸੇ ਵੀ ਤਰੀਕੇ ਨਾਲ ਕੋਈ ਡਿਸਕ੍ਰਿਮੀਨੇਸ਼ਨ ਜਾਂ ਕਿਸੇ ਕਰਕੇ ਤੁਹਾਡੇ ਘੰਟੇ ਘਟਾਏ ਜਾ ਰਹੇ ਨੇ ਤਾਂ ਉਹਦੇ ਬਾਬਤ ਤੁਸੀਂ ਪ੍ਰੋਪਰਲੀ ਸ਼ਿਕਾਇਤ, ਕੰਪਲੇਂਟ ਜਾਂ ਕਿਵੇਂ ਆਪਣੀ ਜਿਹੜੇ ਹੱਕਾਂ ਕਰਕੇ ਤੁਸੀਂ ਕਿੱਥੇ ਲੜ ਸਕਦੇ ਹੋ। ਸੋ ਸਾਰੀਆਂ ਗੱਲਾਂ ਬਾਤਾਂ ਕਰਨ ਲਈ ਮਿਸਟਰ ਸਟੀਫਨ ਫਰਗੂਸਨ ਸਾਡੇ ਨਾਲ ਨੇ ਸਿਮਪਸਨ ਥਾਮਸ ਐਂਡ ਐਸੋਸੀਏਟਸ ਤੋਂ। ਹੈਲੋ ਮਿਸਟਰ ਸਟੀਫਨ ਫਰਗੂਸਨ, ਵੈਲਕਮ ਟੂ ਪ੍ਰਾਈਮੇਸੀਆ ਟੀਵੀ।
Thank you very much for having me. I'm very happy to be here.
How are you doing, sir?
I'm doing very well. How are you doing?
I'm doing amazing. Thank you for being here today. So we'll be talking about this employment laws. So let's talk about this thing first. Like when does an employer, like the employer, have the right to terminate an employee's contract? So what are the rights they have? So can they terminate anytime any of their employees' contract?
Generally, yes. An employer has the ability to terminate an employment contract with one of their employees at any time, as long as it's not for a discriminatory reason. But an employer would have an ability to terminate that employment contract with one of their employees. The only issue that arises is that they have to give that employee the proper amount of notice or the proper amount of compensation in lieu of notice when they are terminating one of their employees. And if they don't do that, then it can be deemed what's called a wrongful dismissal.
And if an employee is leaving the work, like there are no conditions for an employee to leave the work?
Generally, no. An employee can choose to leave their employment at any time. There possibly would be terms in an employment contract where an employee would have to abide by giving the proper notice to their employer. And if they didn't do so and the employer incurred some losses, then it's potential that the employer could go back to the employee for some compensation. So very important for the employee even to pay attention to their employment contract as well.
Can you tell us about some of the wrong ways of dismissal of an employee?
Well, the one big way that an employer could wrongfully terminate an employee's employment contract would be if they did so on the basis of a discriminatory ground under the Human Rights Code. So, for example, if they terminated an employee on the basis of their age, their gender, their religion, their ethnicity, then they could face a legal claim for a human rights violation. And they would have to not only pay out to their employee some compensation for what they're entitled to for proper notice for termination of their employment, but they could also owe compensation for what's called loss of dignity or loss of self-respect. So there could be some additional compensation that the employee might be entitled to if the employer dismisses them for some of these other reasons that are not legal.
So the reasons you just were talking about, this reason, the reasons related to the sex, gender, or like any other thing, what is employee supposed to do in that case?
Well, they shouldn't be terminating anybody for those reasons. And so that's why that legislation is there, is to protect people of these various minority groups, the disabled, certain genders, certain religions. An employer shouldn't be terminating, anybody's employment for those reasons. So there's no way to get around that legislation. They simply shouldn't be doing it.
What proof does an employee need to provide just to make them to the court, or how do they justify their statement that someone is being treated like that at work?
Well, it would depend, fact specific to any situation. So it would largely depend on the facts that are, in front of that specific employee. So the communication or conduct of the superiors, the supervisors, managers, owners of the business, what some, co-workers can corroborate in terms of how they're being treated compared to how the employee that is saying that they're being discriminated against is being treated. So it's really just the same evidence in any civil claim that you would have to prove that the employer is making decisions on somebody's employment based on some of these discriminatory grounds.
And what is exactly the right way of dismissing any of the employees, the exact right way?
So as long as you're not dismissing them for discriminatory reasons, if you're just dismissing an employee for reasons of, you didn't want them to work there anymore, you were unhappy with their job performance, or you were downsizing, there was some economic reason for terminating their employment, the right way to go about that would be to ensure that that employee is given the proper amount of legal notice to the claim. Or if you don't want to give them notice, then you have to give them the proper amount of compensation or severance pay in lieu of notice. And how that is determined is, firstly, if there is a written employment contract between the employer and the employee, that would usually dictate what an employee is entitled to. If there is no written contract, or in a lot of cases, even if there is a written contract, we're able, as lawyers, to say that an employee should be entitled to more than what's in the written contract, then it would commonly go under the common law for what a employee would be entitled to. And how that's assessed is the courts would look at things like, how long has an employee worked with this employer? What's the nature of the job? What is the age of the employee when they're being dismissed from their employment, and the likelihood that they'll be able to find new employment in that specific field? And the court will then look at those circumstances and make an award of what an employee could be entitled to. It's very fact specific, but a general rule or rough guideline would be for every year that you've worked there, they should be giving you at least 1 month of notice or 1 month of pay in lieu of notice. But there are fact circumstances that can make it greater than that or slightly less than that. There's no exact term, but a rough guideline would be 1 month for every year you've worked there.
What if an employer is just decreasing the hours of the job? Is this still, the complaint can be made in that case?
Well, an employer, if they are changing a material term of the employment contract, and so through their own conduct, if they are either reducing hours or they're changing the material nature of the job, and they're essentially making it very difficult for that employee to continue on in their current job circumstances, then the court could say that this is what's deemed a constructive dismissal. So rather than the employer formally terminating the employment, they have made it essentially such that the employment contract has been terminated. And if that has been deemed to be accepted, then the employer will be on the obligation to pay that employee the proper amount of compensation for dismissing their employment.
So how much do you see this compensation coming from for one job?
I mean, it all depends on how much a person is earning, and it all depends on how long they've worked there.
For example, they're earning 60, let's make a scenario, they're earning 60,000 a year.
Yes.
They work there for 2 years.
So if they've worked there for 2 years, then generally I would say it's somewhere, and depending on how old they are, you'd probably be looking at somewhere between 2 to 4 months, I would say, of compensation. But again, very fact specific. The high end of the range, usually the courts have set at around 24 months. And so that's usually the highest end. And within that framework, then it'll be very fact specific to the scenario of that dismissed employee.
Okay. And any kind of proofs you suggest an employee should gather before leaving the job, or if they're going to court, what do they need to have in hand?
Well, I think a very important thing would be, before you resign from your employment, if you feel like the circumstances are made such that you cannot continue, you should talk to a lawyer before. So you should not be just handing in your resignation before you speak with a lawyer, because there may be legal complications with you resigning as opposed to saying, I have been dismissed constructively from my position. So the first thing I would say is, before you do anything, if you're confronted with an untenable or difficult employment situation, is speak to a lawyer about your circumstances and get some advice. And then in terms of going about proving your claim, I think correspondence, again, between your employer is quite important, and your employment file, you will have access to those records, and so those, once they're obtained, will be important evidence in the claim as well.
Perfect. I think that was it regarding this employment law. Thank you so much for coming. And anything else you want to say about what are the other services Simpson Thomas and Associates they're providing, and where are your offices? Anything about that? Details?
Yes, well, yes, we're a full service firm. We have lawyers that specialize in family law, employment law, like myself. We do all kinds of personal injury claims, so slip and fall, occupier's liability, medical malpractice claims. We do wills and estates litigation, and we do all kinds of general civil litigation, so business litigation, anything that requires any kind of lawsuits that are brought in court. We do all of that kind of work. We have a new office that is opened in Surrey, and we have an office in downtown Vancouver as well. We're happy to meet anybody that wants to give us a call. We can arrange a consultation.
Thank you so much, sir. Thank you so much.
Thank you very much for your time.
Thank you, sir.
Thank you.
So ਇਸਨ ਸਾਡੇ ਨਾਲ ਮਿਸਟਰ ਸਟੀਫਨ ਫਰਗਿਊਸਨ ਸਿੰਪਸਨ ਥਾਮਸ ਐਂਡ ਐਸੋਸੀਏਟਸ ਤੋਂ ਅੱਜ ਦੇ ਪ੍ਰੋਗਰਾਮ 'ਚ ਇੰਨਾ ਹੀ। ਮੈਨੂੰ ਜੋਗਰਾਜ ਸਿੰਘ ਕਾਲਾ ਨੂੰ ਦਿਓ ਆ ਗਿਆ। ਤੁਸੀਂ ਦੇਖਦੇ ਹੋ ਪ੍ਰਾਈਮ ਏਸ਼ੀਆ TV, ਤੁਹਾਡਾ ਆਪਣਾ ਤੁਹਾਡੇ ਲਈ।